All right, well, good afternoon, everyone. Welcome to our webinar, Maximizing Control and Family Harmony, Trustee Selection and Domicile. And this is our sixth session in our Beyond the Portfolio series. We've had numerous speakers over the past few weeks. We've heard from Medicare expert Jamin White, family caregiving expert Annalie Kruger, long-term care expert Scott Olson, life and disability insurance expert David Gasworth, and estate attorney Matthew Jacobs. So if you've missed any of these sessions, replays are on our website at www.centman.com, CENTMAN.com. I'd encourage you to listen to these if you haven't already. In the spirit of recorded sessions, today's webinar will be recorded as well, and we should have it on the website for replay sometime later tomorrow. If you have a question during today's webinar, please put it in the chat box or the Q&A box, and we'll get to it at the end of the program. And now I'm pleased to introduce Christopher Holtby. He is the co-founder of Wealth Advisors Trust Company, an award-winning trust company based in South Dakota. Christopher's journey began with a successful 6-year tenure at Ernst & Young, one of the top accounting firms around the world, where he served as a senior manager, and he co-led their multifamily office focused on investment and generational planning. Now, driven by a vision to create a more advisor-friendly trust solution, he and several of his colleagues branched out to form what is now Wealth Advisors Trust Company, which now serves both financial advisors and clients across the country. Christopher focuses on educating others about trustee industry and helping advisors find the right trust solutions for their clients. And that's actually how I met Christopher. I had many questions about setting up trusts, so he's been very helpful. He's also written several practical guides like Directed Trust Made Simple and the Trustee IRA, and has contributed to industry journals. So he's a very well-respected voice in the trust services industry. And in line with our own commitment to clients of owning the same securities as our clients, Christopher and his family are clients of his trust company. So underscoring his dedication to the same high standards that he brings to his professional relationships. Originally from Toronto, Christopher holds a BA in psychology with an emphasis on statistics and has a minor in English literature from the University of Arizona. On a personal side, he's a devoted family man who loves spending time with his wife and his 3 sons and their active lifestyle, skiing and hiking. And he's joining us today from South Dakota, where it's 45 degrees and snowing outside. So I'm thrilled that my friend and colleague Christopher could join us today to share some valuable information with us. So Christopher, welcome.
Oh, thank you so much, Scott. I really appreciate it.
Yes. So you want to take the screen over from this point?
Yes.
Just sharing, and you can
just one moment. There's just a snafu here. Just one moment.
Want me to run the slides?
I got it. Sorry.
There you go.
There we go. Okay. So one of the things that we find that families are always trying to figure out is how do they sort of control, but at the same time have family harmony? And part of that, when you were dealing with wealth, is the trustee selection, what is the trust location, and how all of that sort of merges together. So when Scott and I got together and he was thinking about a moment to educate clients and such, is to really, how can you maximize these two things? Control with family harmony, and then that ties into the trustee selection, and then also the trust location, domicile location. So the first thing, the way we see the world is this is your financial team, right? You have the bankers, the CPAs, and so on. What we've seen over the last 30 years is sort of a massive shift. I mean, almost tectonic shift, where the financial advisor sees everything, right? The banker used to offer liquidity or capital to grow business. There's so many options today. The CPAs are just so swamped with work. They're very reactionary. The trust officer on our end, we just see a narrow sliver of a client's overall financial picture. The estate attorneys, sort of like the CPAs, they are very driven by projects, but they're not engaged all-inclusively throughout the year in a holistic perspective. So really what we see differently is the financial advisor sees the whole picture. They're the quarterback organizing property and casualty, the life insurance, the tax side, the estate planning, the operating assets, the investment assets, retirement planning, legacy planning. And this has been a huge quiet change over the last 30 years. So we, as a corporate trustee, only work with financial advisors and their clients. We do not manage money. So it's a very interesting shift. And what it really does is it allows everyone to play a role, and that's very collaborative, but there can only be one thought leader. And in our opinion, the thought leader should be the person that sees everything. So I know some CPAs and estate attorneys don't always agree with that, but from our perspective, we think that's the best choice. And we see that only growing even larger over the next 10 to 30 years. So just want to go over something that's really interesting from a client perspective and all the other pieces. Now, it's really important. What is a trust? So I always like to say a trust can own anything, like literally anything. We have trusts that own guns, cars, paintings, oil and gas, 12-story buildings, apartment, commercial. We have assets all over America. So the most important thing is that what a trust can own can be literally anything. The other thing to remember is a trust is a set of words that says who can do what. And it is the lay of the land. It's the constitution, so to speak, of what happens with future generations. Now, a trust can be created from a will. That's called a testamentary trust. Or it can be created while you're alive, such as a revocable trust or an irrevocable trust. An irrevocable trust, some of you may be familiar with irrevocable life insurance trusts. You may be used to trust for gift tax planning. And then, of course, all of you are familiar with a revocable trust. The most important thing when you are planning around a trust or an estate planning or a legacy planning is you're thinking about the philosophy of your money and your family, and not just for your children and grandchildren, but also what could be really long-term money. It could be great-grandchildren and great-great-grandchildren, when you are dealing with larger pools of money. A lot of individuals and individual clients say, well, how complicated is it? And I sort of like to say is you can make it as simple as tying your shoelaces, or you can make it as complicated as explaining the money multiplier system to to our teenage kids. The issue is don't worry about the complexity, worry about the end in mind. And what we see best when you are thinking about estate planning or legacy planning is always begin with the end in mind in your words. What's important to you today? And then Scott will work with you in uncovering the other issues, such as who should get the money, How should they get the money? When should they get money? Tied through distributions, because it's a really delicate balance between how you're using assets to spur a sort of a support mechanism versus do you want to avoid creating an enabling system? And there is no hard and fast rule around what is an enabling trust distribution and what is a supporting trust distribution. I think all of us would agree you don't want to create trust fund kids or trust fund kid mentality in your distributions. So that's why the first stage when you're thinking about, do I use what type of trust, is really going back to beginning with the end in mind. The other key thing, and this is really, really, really important, keep the intent simple. Because think of a trust written in 1950. We were still using typewriters. The internet was still about 25 years away in its infancy. Cell phones were 40 years away. So there is a future that we cannot even imagine what is going to happen in the next 50 to 100 years. So it's this weird balance that you want guidance, but you don't want it to be too constricting. Think of trying to bend metal when it's super, super cold, right? It'll just crack. And so this is where the philosophy, again, I'm going to keep harping on this, in your own words. And the other thing that's kind of interesting about this, I underline this word unflappable and flexible, right? That's sort of weird, right? It's almost like oil and water. What I mean by that is, your children and your grandchildren, without question. Very few of you will know your great-grandchildren as well as you do your children and your grandchildren. So as you think about planning for the future, for this generation that you will never really, really know, don't worry too much about how much flexibility or will they like it, will they not like it. We see families having a greater impact on their kids and grandkids because there's joy there, there is participation there, and this is really where you'll have the greatest impact just because you know them the best. So just, I would say, don't get too hung up on the great-grandkids. And I say this with all humility, and we see this. We have a lot of great-grandkids, great-great-grandkids as clients, and some of them are unappreciative on what you, the creators of this wealth, took to get it done. Whereas your kids and your grandkids, they saw what you went through. I mean, they experienced it. So just something to keep in mind as you discuss this with Scott and Rachel and the rest of the team. So, like everything, a trust can achieve about 6 things. What we find is you want to prioritize what is the thing that is important for you. And if you try to say, I want to give less to the tax man, but I want to protect myself and I want to get all the distributions, that doesn't work, right? So what you want to do is you want to prioritize what is the number one thing. So, in Dallas, we could say that Jerry Jones, his number one thing is making money, not winning Super Bowls. Right? Am I allowed to say that? No, maybe not. But anyways, I think we all know what we mean here is, and I live in Dallas, by the way. So I'm a Steelers fan, but I live in Dallas. I always hope they win. But anyway, what I'm trying to imprint here is stay and rate what is the most important thing. If you have competing things, maybe you create a separate trust. Maybe you don't. So take that into consideration. I think the one thing that Scott was really interested in was protecting money from shady lawsuits. And I think what we're talking about there is ex-spouses. We're talking about creditors. So when you use a trust in South Dakota, these assets are protected. And the reason that they're protected is they separate the ownership of the beneficiary being able to enjoy the income, but they don't technically own the asset. And in Texas, that ownership is still somewhat connected between the beneficiary and the trust assets, whereas in South Dakota, it's completely separate. That's why billionaires use South Dakota to create these sort of trusts to protect from shady lawsuits. The other interesting thing is I write here, keeping things on the down low, maybe, is another way of saying it. South Dakota, interestingly, when you go to court and you make a change to a trust, South Dakota doesn't record it. It's sealed, private, forever. It's the only state in the Republic where that is written as a trust statute. It's in the Constitution of South Dakota. And the reason why this is important is in light of, in the age we live in today, where everyone's getting broken into, we have all these cybersecurity breaches. Some families just want to keep things quiet when they have to go to court to make a trust change. Doesn't always happen, but that's another sort of subtlety of what some states can offer, like South Dakota. I want to stop there. Scott, should we just wait for questions to the end? Oh, sorry, Scott, you're on mute.
Sorry, okay, didn't want to disturb. So on that question about going to court to make a change in your trust.
Yeah.
What type of changes into what kind of trust do you have to go to court to make a change? Can't you go with a revocable living trust, just go to your attorney and saying, hey, add this new grandbaby, or, add this property to my trust, or make some changes without having to go to court? Can you distinguish between the two?
Great question. So these are for revocable trusts where you never need to go to court, to your point, Scott.
Okay.
Irrevocable trust is when you need to go to court. And it could be you want to make beneficiary changes. It could be you want to change the distribution rules. It could be you want to decide to change when the trust ends. It could be the change of what the investments could be inside, or, what are the allowable investments inside of the trust. So it could be any number one of those things. Sorry, I'm just getting over a cold.
No, that's okay. That's okay. Another question, and you tell me if you're going to come up on this, we can do it later, but if you have trust, when we're talking about goals to achieve, maybe you're setting up for your family and you've got kids that are minors, or maybe you're going to include friends or family members that, as a beneficiary of the trust, that they may be spendthrifts, they may have substance abuse problems, something where they may not be able to manage the money or the withdrawals in an orderly fashion that would allow them to have that trust and that income that can be generated from the trust last a long time. And you talk about the protective nature of the trust and how it can serve almost not from a tax deferred basis, but like a pension or Social Security, where this is a consistent income.
Yeah, so great. I love this. So what's actually kind of cool is in the middle section of a trust document, whether it's a revocable trust or an irrevocable trust, it says, here's how people get to enjoy the money. Now, the typical trust document will say health, education, maintenance, and support, right? So health and education, pretty straightforward. Where the rub happens is, well, what is maintenance and what is support? And everyone, this is the art of being a trustee. This is where the trustee is trying to interpret the other sentences in this paragraph that is your intent. So, for example, Scott, if it says after this, distributions are for health, education, maintenance, and support, it says in the lifestyle that they're currently accustomed to. So what that means is it limits that if they go, well, I want a 911 Porsche, well, but they're a professional lawyer making $200,000 a year. That's not underneath that definition, right? So what you want inside of this distribution section is to create context of what you want your future beneficiaries to enjoy. You could even limit it to not more than 4% a year, or you could say not more than 50% of your adjusted gross income on your tax return for any 1 year. So there's a lot of flexibility, Scott, of what your clients can put in to create that quote unquote pension plan. And what he means by that is a trust can add to support someone, but not enable someone where they don't have to work, right? And that's the art, is if you're dealing with a $10 million trust, what sort of parameters, again, this goes back to the legacy, the philosophy of money and family, what sort of parameters do you want around the distributions? Again, enabling versus supporting. And all this comes in the distribution section. Does that sort of give some better context?
Yeah, it does. And I was, with a recent client that was going to take advantage of the current estate tax gifting limits before they sunset at the end of 2025. There's a lot of people trying to do some of that gifting and estate planning this year and next year. And one example I saw is a family wanted to pass on some money today to some of the kids, maybe some of the grandkids, but have the trust say only, give them a certain amount of money for the next couple of years, and then don't give any more money until 10 years later, so that they got to enjoy a little bit of the money now, but not enough to become enabled, like you say. It gives them a chance to live their life. How do they handle their money? They wouldn't be able to go off and buy a bigger house or a more expensive car, do things that would maybe lock them into higher monthly payments, right? Because there was some separation, and it gave between when the money flowed and having a trust document. However you want to work it out, those are the possibilities with a trust, right?
And you're right. So you really want to
Because if you were,
think
Christopher, because if you were to say, well, I want to give somebody some income, I just go buy them an annuity and they'll get an income. But the annuity doesn't give you the controls to dip into principal if there's an emergency for those health needs or what have you, right? The trust
correct.
gives you that flexibility.
And that's the beauty of a trust over annuity, is there's a lot of flexibility, and it is not complicated as long as you go back to beginning with the end in mind. And really, Scott, this is what your team brings to the table. So
Great.
on the next slide, what I wanted to go here is, this is typically the 3 trustee choices that everyone on this call can make. You have individual trustees, family and friends. You have an advisor-friendly trust company like us. And then there is probably what everyone really knows is the traditional trust company model. That'd be firms like Frost Bank, Bank of America, JP Morgan, Northern Trust. So the traditional trust company model, they control everything. And it's odd why they do that, because what they're really, really good at is distributions. What they're average, and I'm being charitable, is on the investment and on the tax returns, because they don't do any tax planning. They just, plug in numbers, sign it, file it, and go on to the next. And I know this because at Ernst & Young, we saw a couple of big banks use us for tax returns, and there was no planning. It was just plugging in numbers and signing away. So, and then if you look at sort of the family and friends, most people don't know that when a family friend is named as the trustee, they're legally liable to the IRS for every single tax return. And it was interesting, Scott, I spoke to one family friend who resigned on an $8 million. He didn't resign originally. What he said is, hey, can I be around but not have any liability? And what we did is we went to court, got it amended. And so what he did is he provided context to the trust officer around trust distributions. So it worked really, really great. And he goes, yeah, this wasn't in the brochure that my buddy told me about. Because what he saw is that the beneficiaries, his friends' kids, would be texting him any time of day or night. There was no hours of when he had to work. He was always on call. And then he realized that he didn't realize he had to document everything. He didn't realize he had to give them accounting, principal and income accounting, which is different than tax accounting. And he goes, look, I'm honored to be chosen, but this is not what I signed up for. So what we're seeing, Scott, is a lot of people sort of go with a Goldilocks solution when they're dealing with bigger amounts, sort of, $3, $4, $5, $10 million, where we do all the boring work. We can work with a family friend. We can work with a family member. I will tell you the greatest way to destroy a family is having a sibling being the trustee for another sibling. One caveat. If it's a special needs trust, it's all good. And some of you may be saying, yeah, but Christopher, it costs money to use you. Yes, you are absolutely correct. We do not work for free. $10 million, we're charging 0.36%. So is that free? No. But remember, if a family friend or a family member is the trustee and something goes wrong, your beneficiaries lose twice. The first time they lose is the mistake. And the second time is if that family friend or family member gets sued, they're going to use trust assets, which they're allowed to defend themselves. So now your beneficiaries have lost twice. We see a shift where firms like ours are working with the family friend because basically we're doing all the heavy lifting. We're sometimes having to make the hard decisions. And so, but the family friend or family member is there as context.
Christopher, what's a hard decision? Can you give an example or two of that?
I want to go, let's say, and I saw this once, the middle son was named as the trustee.
Mhm.
The oldest son was really upset because he thought, I'm oldest, I should be the trustee for all my siblings. Middle son had to make a decision for his sister, who's younger, to go on a $60,000 European vacation for 8 days. And he's like, okay, it says health, education, maintenance, and support. It gave based upon how you live. And, she was earning like $150,000. Her trust was about $8 million. She was 54 or something, 53. And he didn't know, wow, if I do it, shouldn't I? He agreed. And then his older brother wanted something even more extravagant, and he said no. And then, the roof blew up. And that's when he reached out to the advisor, and the advisor brought us in, and he literally resigned. He goes, I'm out. So, but the parents did it because they knew he was really responsible, super detailed, wizard smart, and would do the best that he could. But it was just crushing him. He didn't want to make a decision on his brother or sister of how to use the money.
Got it. Thank you.
So, anyways, these are the three choices. Also remember that individual friends and family have the same power as we do, or the traditional trust company, but they have no regulatory oversight. There was no one looking at how they are doing the work. Are they doing it correctly? Are they paying themselves too much money? All the horror stories that you hear are typically when a family friend or family member starts taking fees, and that's where the problems start to happen. The term is self-dealing, and this is more for the bigger amounts. But if you're going to use the blue option, I would sort of have someone to work with, because this is not their day-to-day job. And actually, Scott, we did a presentation called Individuals Don't Know What They're Doing. And I'd be happy to send that to you after this presentation if you would like.
I'm sure that could extend beyond just trustee services, but yes, that would be great.
Okay, right. Yeah. And it was really just talking about individual trustees don't know what they're doing. Sorry. It was individual trustees.
Yeah.
Right. So next one. A lot of people are wondering, what does it look like when you work with an advisor-friendly trust company? What's important is you have Scott here doing the financial planning, the wealth management. You know, he's making the custodial decision, and we're doing the trust administration, the distributions, we do the tax reporting. Always remember, we sign the tax return, we don't do the tax return. Scott will work with you on who should be the best CPA, and then you have the client where we're all working towards. What's interesting is the trust officer and the financial advisor coordinate the distributions tied to the financial plan. And the reason is a lot of you will have retirement assets, you'll have taxable assets, you'll have maybe even operating businesses. All this has to be coordinated into a financial plan. So when the trust is giving income, you want it tied to the overall financial plan so it's nice and, nice and coordinated. So that's how the trust officer collaborates with the financial advisor. And it's a very elegant solution. And it works really, really well because we all used to be advisors. So we understand what the advisor teams are going through in thinking and what they're doing. And so that is a key solution. Can I go to the previous slide,
Yes.
Scott? I just want to highlight one thing. If you're going to choose an individual trustee, they don't have to be the smartest person. They don't have to be the oldest person. They have to be impartial. They have to be humble. And they have to have this ability to say, I don't know. And I will tell you that men do not make good individual trustees, just like men don't like going to the doctor's office. So the worst individual trustee you can choose is someone that has 5 PhDs from MIT that works at NASA, because that fellow is paid to know, period. And for him to say, I don't know, is almost like this wooden stake through the heart. Like there's something utterly wrong with him. So that's why women make better individual trustees, because they're very comfortable saying, I don't know. I'm going to call the attorney. I'm going to call the CPA. I'm going to call Scott, and we will figure this out. So a little bit of a sidebar there. In terms of age, you don't want them too young or too old. So if a lot of you are naming a friend as the successor trustee and you're 70 and they're 70, that's not the most optimal choice, because they're aging with you. You sort of, as you reach into your 60s, you want someone 10 years-ish younger than you. And then typically what we're seeing is always a stopgap, which would be someone like us, right? A corporate trustee that lives forever, so to speak. Sorry, I just want to highlight that. And then this is where we go through about how you pick a trustee. And it makes no difference whether you start on the individual trustee side or on the trust company side. We give some highlights here, like I talked about, what makes a great checklist. Always remember that these people that you're choosing as an individual trustee have never done this before. And so it is a badge of honor, but they're going to be pretty freaked out, especially the ones acting as the executive. I'm so sorry. So as you think through all the decisions, always remember on the trust company side, the biggest sort of split is, do you want the trust company to manage money or not to manage money? We, for example, will never manage money. We think it's good to have that separation. So that's a key issue here. And this is something Scott can send out. And it's a great discussion piece about how to think through this whole process. Scott, anything you want to highlight here, or are we good?
I'm going to save it for the Q&A. Just keep going.
Okay. All right. Lovely. A lot of you are wondering this concept of South Dakota trust law versus Texas trust law. Just quickly going down memory lane. When this country was founded, the 13 colonies were arguing about all sorts of things. One of the things they're arguing was property taxes. Trust law was tied to property taxes. So when the states controlled their property taxes, they also got to control trust law. That's why we're the only country in the world that every province or state has its own trust law. South Dakota, in the spirit of capitalism, decided to make trusts modern. And everything about South Dakota trust law is around control and choice to you, the end user. So one of the things that, we go in here is the privacy. There is no privacy if you go to courts in Texas. It is public as soon as possible. Whereas in South Dakota, it's sealed private forever. In South Dakota, there's this concept of what's called a directed trust, which means Scott manages all the money, we do not. And the benefit is we charge less money because we have no risk, right? Scott has all the risk of managing your money. Also changing trusts, as we talked about in the very beginning, the irrevocable trusts is lickety split. I mean, this state is designed to make amendments to trusts. What's interesting is irrevocable does not mean irrevocable. Now, you got to be careful about generational skipping trusts and that sort of thing. You can't change those, except for the boring parts about the governing law and who manages the money. But everything else can pretty much be changed through the courts. And so that gives really everyone a lot of flexibility about what can happen. And you're wondering, why wouldn't Texas make their trust laws as awesome as South Dakota? I don't really know the answer, but I think with most things in America, if you follow the money, it kind of shows you the motivations. And it sounds to me like the Texas bank lobbyists don't want firms like us competing against them, holding them accountable. So that's probably what happened. Again, that's a wild guess, because Texas is very entrepreneurial in everything except trust law. Very curious. So anyways, if it ever changes, we'll move to Texas. I mean, we are focused on clients. So I just wanted to have a comparison here. I think one other thing, and Scott noticed this, he goes, what's the difference between a trust that lasts for 300 years or infinity? And the answer is nothing. I mean, as a country, we're not even 300 years old. So if anyone ever says, well, Wyoming, that's another top trust law state, their trust laws last for 1,000 years. You know what? That's literally irrelevant. So just to let you know, there is no difference between 300 years and infinity. So if anyone tries to tell you infinity is more important.
And Christopher, how about in California? Do you happen to know, are the trusts limited to length of time in
Yes,
California?
California, it's 121 years generally. It's sort of 21 years after the last beneficiary's lifespan passing. So I think it's like 121 years.
Okay.
And if you really think about it, for a trust to last 121 years for one beneficiary, we're talking about, or, multiple, kids, grandkids, great grandkids, probably in the 20 to $30 million range. So please don't get hung up on this. It only lasts 121 years. There are many more reasons to not use California trust law. Taxes, great place to live. I wouldn't want to pay taxes there. So just don't get hung up on the duration of the trust. Focus more about privacy and flexibility.
Christopher, it doesn't matter where you live, you can set up a trust in a South Dakota trust, right? It doesn't matter that I live in Texas or we have clients in California. They could choose, we could all choose to do South Dakota.
Correct.
Trust.
I mean, we have clients in Hawaii, Washington, Maine, Florida.
Okay.
Hawaii. No, I already said Hawaii. Yeah, we have clients all over the place.
Okay.
So the advisor is going to be in the local location, and then, we're sitting in South Dakota. And then, actually, the story of how we started is when we were at Ernst & Young, we had some friends like Scott who asked us, what are we dealing with corporate trustee issues? And we were stuck using, the Bank of America's, the Frost banks. So when we left Ernst & Young, we reached out to our buddies in Dallas and said, hey, we're going to create a trust company designed for wealth advisors. And, we started with like 300 million, and it worked so well and they liked it. We just rolled it out nationally. So it started out just helping a bunch of friends who were advisors like Scott. And that was 15 years ago. And one advisor goes, I didn't know a trustee could be kind and responsive. So that's what we're known for, and it makes it much more fun doing the work that we do. So
And when you talk about being an advisor-friendly trust company, that allows us at Century Management, we manage the money, we do financial plans, build a relationship with our clients. We like to build it with their kids and grandkids if possible. We build that relationship, and by working with you, your company specifically, the benefit is that we could be named in the trust as the financial advisor. They can the beneficiaries can always change that, but we're named in the trust as the advisor. If they were to use a Frost Bank, Northern Trust, or JP Morgan, they don't give you that option. They're going to be the money managers, and Century Management loses out on the client, loses out on the relationship, the family loses out on that relationship because it's all going to that trust company for an all-inclusive relationship at that point. Is that a fair statement? Or
it is, but it's even deeper than that.
Okay.
Think of all the knowledge you have about your clients' personal issues, family issues, right? Like you get the phone calls that no one else gets. If they go to a Frost, all that's gone. And now they're just a number. With your firm, it's part of a tight-knit relationship. And that knowledge, that legacy knowledge, can go from the parents to the grandkids, to the great-grandkids, however it works. But that legacy knowledge goes from one generation to the next. Whereas if it goes to a bank, it's just erased. It's gone. And people don't realize that. So the power that you have, Scott, is you can work with us knowing we play a position, but we're not the thought leader. And your firm is designed to go from the next generation to the next generation. And so really, you've got your clients now can have consistency of their philosophy of money and family. And man, that's awesome. And that's what everyone wants. It's just, how does it work? And so that's why some people call us the Goldilocks trustee solution. So
We talked about this a little earlier, but could you just maybe spend one more minute on it, that when you're setting up a trust for your beneficiaries, this is considered a non-marital asset. So your kids, they grow up, they get married, they had this trust, it's a non-marital asset. So, if the unfortunate happens and they get divorced, this is not part of that divorce settlement. One is that true? And number two, if they're already married and you set this trust up for your adult child and then they get divorced, is that still considered a non-marital asset?
So let's do with the first option.
Okay.
If it's done before they're married, it is absolutely separate property.
Okay.
With one caveat, the net income needs to be pushed out, because you've got to be careful that that income that's generated in the trust is not considered community property, which over time could build up and make it as, part of a divorce settlement. So number one, always push out the net income. The other thing, and this is to your point, if they're already married, is A, you need to push out the net income. B, it protects, right? Because it's set up just for them. The wife is not, or the wife or the husband, whoever it is, the husband is not included as a beneficiary. The children may be. You can even put more specific language that if they get married again, let's say their daughter divorces, protected. If she marries again and her new spouse has children, the trust can even say, you can't make distribution to the new stepchildren, right? Now, I'm not saying you are going to do that, but that is the flexibility. One of the things we see a lot of lawyers say, well, in Texas, if I am a trustee of my own trust and I get divorced, I'm protected. That assumes you followed all the rules exactly for that to happen. And most people who are the trustee of their own trust, what they do, Scott, is they just go, well, it's just, it's just my money. I can do whatever I want with it. They buy a house in it. They buy cars, right? They use it as though it's not even in a trust. And so when you get divorced, the lawyers step in and they start doing all the forensic accounting, and they go, you know what? This was really marital property. They bought a house, they bought cars, everyone used it, and now you've got a big problem. So if you're really dealing with bigger amounts, this is where using a corporate trustee to protect in a divorce setting makes a lot of sense.
And it's not that you have to be the exclusive trustee, but a co-trustee. You
Yes.
still solve that, right, on there.
Right.
So,
yeah.
So what happens if you retire, I retire, something happens to our companies? What happens to somebody who signed up, said, oh, Century Management's in the documents, we're using South Dakota Trust, they're using our services. What happens in those transition roles or options? Can you talk about that for a moment?
So we've built our firm sort of like the Ernst & Young model. It just goes from one generation of ownership to the next. So it just continues on forever. And it works that way at McKinsey, at Ernst & Young, at Bain & Company. So we're just following best practices. As sad as it may be when I pass away or retire, that's really not relevant. What is relevant is the mechanism and the institutional processes, sort of like the Marines, right? The Marines have been around for 200 years, and no matter who's running the Marines, the philosophy and intent remains the same. And that is what makes them such a potent force within the U.S. military. Same thing with us.
But let's say at the extreme, though, the younger people that come up in the firm, they buy into it, they're your eventual replacements. They all decide they want to sell this to another trust company, and it gets to that level. What happens then to the trust?
So we've built in our trustee language adds a key word that very few trust companies add, removal language. We want beneficiaries the power to remove us as a corporate trustee and to appoint another corporate trustee. And the reason why we want this is we want accountability. Because, Scott, look, humans by nature can be lazy. And to avoid that laziness, that sort of institutional mindset, is we hold ourselves accountable where a beneficiary can fire us and appoint another corporate trustee just like that.
And the
So,
same type of language in your document would be true of us as the advisor, that they
yes,
could change us out as the advisor at any time,
correct.
right? So they're choosing to work with us, work with you, but anytime the co-trustees could make a change.
Right.
So
Humans
they're not
do,
locked in, they're protected in that respect.
right. And people like Frost and US Bank, all they have is resignation language and appointment language. Unless forced upon by the lawyers, they don't add in, they never suggest, oh yeah, make it easy to remove us. So we just know humans do better when they're accountable. They think better, they act better, they sleep better. They're just happier people. So we're just going with time-tested, good best practices.
At what level of assets do you think it makes sense to start having a co-corporate trustee, or bringing in your firm? You charge about 0.36 or so, you were saying earlier, but what level of assets do you think it makes sense, and when do you think it makes sense to do that?
So our minimums are 2 million. Our mean is 4 million. Our average is 7. So I would say somewhere around 3 to 4 million. At 2 million, we charge 45 basis points. At 10 million, we're about 36, 37 basis points. So, in that range is where clients should begin thinking about working with a corporate trustee. And remember, we just do that one narrow sliver.
And now what happens, let's say somebody's already got a trust set up and their 2 kids are on there, or a couple of friends, and they're not having to pay any fees right now. They've got all that set up. Can they go back to their attorney, amend the trust to make you and your company the successor trustee? And in that situation, what would click in to make the successor trustee at that level, at the next level up, to make decisions? And 2, when you are a successor trustee, do you charge fees at that level?
So the best analogy I can give you, if we're named as a successor trustee, imagine, we're in the middle of the World Series, right? So let me use this analogy. Imagine you have a pitcher sitting in the bullpen, warming up, but you don't have to pay him anything until he walks out, walks to the mound, and throws the first pitch. That is the way a successor trustee works. We don't charge any money until we actually start doing work. We're doing our thing, we're staying limber, we're getting ready, and when called upon, that's when we start charging fees.
Do you, in your experience, when people are setting up the trust and naming trustees and co-trustees, do you think they're aware of all the responsibilities that they're asking their trustees, future trustees or co-trustees to be involved with? Or is that kind of they just don't know what they don't know?
As I said earlier, that one individual goes, yeah, this was not in the brochure. What I will do, Scott, is I will send you my presentation that I gave to 200 estate planning attorneys in Dallas.
Okay.
And what you'll see is all the different things and issues that are having to be done by an individual trustee. And Look, it's a badge of honor. I've been named as a trustee and I've immediately declined because I don't want to do that work. And I actually know what needs to be done. So I think people do it out of loyalty and love. But once they really get into it, they sort of like, this is not what I signed up for. So,
When
but
setting up the trust,
Mhm.
are you kind of like you said about a lot of the CPAs, they're doing the taxes, but they're not giving the tax advice. When you're setting up the trust, are you helping to give advice on things to think about based on your experience and all that and your partner's experience, or do you leave that part up to the attorneys to guide? How does that work, the advisory part of the trust with you?
So we don't give any legal advice about how to set it up. That's the attorney and you and the family deciding philosophically, what do we want in there?
Okay,
Sometimes the attorney gets really like Charles Dickens creative and they make it super complicated. That'll make it super, super expensive to administer. And so when we look at a draft, we'll be like, yo, you need to make this much simpler. There is one client that had 65 exhibits to a trust.
wow.
And they go, will you serve? And I went, absolutely not. Well, why? It's beautiful. I go, it is, but it's impossible to administer. So really, that's the only time we look at it. Only is it easy to administer? Is it doable? Or is it so complex? It's impossible. So that's the only way we get involved is we look at it from a administrative perspective, but not structurally, all the gift tax or tax planning.
Well, Christopher, it looks like I don't see any more questions, and it looks like we're coming up on the top of the hour. So I think this has been a great discussion. Every time we talk, I always take a few notes and learn something new. So it's always
Thank you.
great to chat. And I see my team and a number of clients are on the call today, so that's great. We'll have this recording on the website probably by late tomorrow for anybody who wants to listen again or share it with a friend. And you're always welcome to call Christopher, call us. We'll
Call Scott.
Put you in touch. So that's
Call
great.
Scott first.
Thank you very much for your time.
You're welcome, Scott. Thank you so much. Have a
All right,
lovely
everybody.
rest of the day.
Thank you for joining. Take
Okay.
care, everyone.
Bye-bye.
Bye.